So, good morning, good afternoon, and good evening. Thank you for joining us in this third session of the series, Deadline or Death Sentence, State Violence and Indigenous Adivasi People's Resistance in India. My name is Lotika Singha, and I will be moderating this session, which is hosted by International Solidarity for Academic Freedom in India, or INSAF India, with London Mining Network. We started this series not merely to impart information. The Adivasi region of Bastar in the state of Chhattisgarh in central India is a microcosm of the worldwide struggle of indigenous peoples against what's happening in the name of development, the rapacious march of the extractive industries, and the resultant destruction of lives, livelihood, and the environment. We hope that this series amplifies Bastar's Adivasi voices exposing the Indian state's violence that is threatening their existence. We also hope it helps in bringing together more people and organizations in solidarity with the struggles of the Adivasi peoples in this region. Our first two sessions examined the Indian state's war on Adivasi communities under the guise of doing counterinsurgency against the CPI Maoist Party, also called the Naxalites. The extrajudicial killings, aerial bombings, and mass arrests under Operation Kagar, and the extensive militarization of the region that isn't incidental, is intended to clear the ground for mining corporations by erasing indigenous presence and suppressing resistance. Today, though, we turn from the assaults in the forests, in the villages, and the roads to a quieter battlefield, the courtroom. For this, we are honored to have with us two speakers, Nandini Sundar, an activist and professor of sociology at Delhi University. Nandini was one of the petitioners in the landmark case challenging the state-sponsored vigilante group Salva Judum and the violence it unleashed in Bastar. Megha Bahl is a lawyer and researcher committed to working on indigenous struggles in the state of Jharkhand. Megha is currently pursuing her PhD in anthropology at Rice University. This session is titled Courts as Instruments of State Power, and that is not a metaphor. In regions like Bastar, courts don't limit state violence. They facilitate it by refusing to act in cases such as those of extrajudicial or custodial killings or of sexual violence. Meanwhile, the same courts actively sustain the criminalization of entire communities. Studies by the Jagdalpur Legal Aid Group in Bastar and the Quill Foundation in the Gadchiroli district of Maharashtra have shown that for those targeted by the state in its war on the people, the courtroom is not a site of redress. It is an extension of that war. The pattern is disturbingly consistent. People are picked up in mass combing operations by the armed police and paramilitary forces, detained without evidence, denied bail, held for years, and eventually acquitted for lack of proof. But by the time the acquittal comes, the punishment has already been inflicted. The prolonged legal persecution devastates lives. Families lose their sole earners, children grow up without parents, and their daily existence is criminalized. Entire communities are forced to live under constant fear and surveillance. While these arrests serve the purpose of keeping communities under a permanent state of threat and subjugation, they also help the state generate numbers. Just as the tally of so-called Naxalites killed is used to project success, so too is the number of alleged Naxalites who are caught. The court lends legal cover to this violence. Because the trial is not about establishing guilt or innocence, it is the punishment itself. To set the context for today's session, I will take you through three cases to show how the judiciary doesn't prevent but actively legitimizes state violence in Bastar. Arjun Kashyap was a 17-year-old Adivasi boy from Chandameta village in Bastar. On 15th May 2015, Arjun went to the market to sell a goat. He never returned. For 2 days, his family searched frantically. Fearing the worst, his father Sulo approached the local court. Only then did the police produce Arjun, not as a missing teenager, but as a 30-year-old Maoist commander with a different father's name, arrested as a co-accused in a case from the previous year. Despite school records and testimonies proving Arjun's age, the court didn't dismiss the case. It simply transferred it to a juvenile court and asked the police to correct the age and the father's name in their paperwork. In Bastar, juveniles like Arjun are routinely picked up, shown as adults, and tried in regular courts. Most families lack age documents and don't know that children can't be jailed with adults. Lawyers rarely intervene, even to transfer cases to juvenile courts. Arjun's case was a rare exception in that it was eventually moved to the Juvenile Justice Board, and after months in an adult prison, he was transferred to a juvenile home. Arjun's first attempt at bail was denied, not due to evidence, but because the court claimed his violence was Naxalite affected and returning to it would be dangerous for him. That is, the court decided he was safer locked up. After months, Arjun finally got bail in December 2015 when witness after witness failed to link him to the case. After that, Arjun attended regular hearings and was due in court again on 31st August 2016. But just 2 weeks before that, on the night of 15th August, India's Independence Day, security forces stormed Arjun's home and abducted him. Hours later, they claimed they had killed 2 Maoists. One was Arjun. They said in the media that he was an absconding Maoist commander with a bounty on his head. His family heard from others that the forces had been seen in a nearby village that morning, dancing and celebrating with Arjun's corpse. When his family tried to speak out, his sister was picked up and declared a surrendered Maoist and detained for months. His father was also detained and beaten and then offered land and money to stay quiet. In 2018, however, Arjun's father, Sulo, filed a petition in the High Court. After 5 years, just 2 years ago in 2023, the petition was dismissed in under 10 minutes. The court relied completely on the state's version of the events and the pending case as proof that the police must be correct in calling Arjun a Naxalite. Yet months later, the others accused in the case were acquitted. Had Arjun been allowed to live, he too would have been acquitted. Many petitions have been filed over the years against fake encounter killings, custodial rape, and disappearances, and have been dismissed. Not one has led to accountability. The Supreme Court's refusal to act even in the Salwa Judum case, despite clear evidence of mass violence and state complicity, stands as a stark reminder that the highest court too has failed Adivasi communities in their struggle for justice. Nandini will tell us more about this case. I will mention Gompad, a village where 16 Adivasi villagers were killed by security forces in June 2012, and a petition was filed in the Supreme Court of India. When the courts finally decided the case, which was a decade later, it did not punish the perpetrators but those seeking justice. The court dismissed the case and fined one of the petitioners, activist Himanshu Kumar. During the proceedings, the government accused him of fabricating evidence and urged the court to direct the Central Bureau of Investigation to investigate the individuals and organizations who were behind such petitions. That is, instead of upholding the constitutional right to seek justice, the court enabled retaliation, asking the state to proceed as it deemed fit, even hinting at invoking criminal conspiracy charges against Himanshu Kumar. This clearly signals that even the highest court will not challenge the state, it will comply when asked. But it is not just those who challenge the state from outside. My last example from Bastar shows that even those within the judiciary who won't fall in line are punished. In 2016, Judge Prabhakar Gowal, Chief Judicial Magistrate of Sukma district in Bastar, was dismissed from service in the name of public interest. Judge Gowal, a Dalit man from a rural background, had done something rare in Bastar. He questioned illegal arrests and granted bail where the police had no evidence. In his last case, he refused to accept the state's version and issued notices to senior officers over the illegal detention of an Adivasi man. Soon after, he was dismissed. A right to information request later revealed that the superintendent of police had written twice to the Chhattisgarh High Court, under whose jurisdiction Gowal presided, complaining that Bastar was a conflict zone, where police risked their lives to arrest so-called Naxalites, only for Judge Gowal to grant them bail or question the legality of their arrests. The letters accused him of demoralizing the forces and urging the High Court to take appropriate action against him. Instead of rejecting this brazen interference, the High Court had complied, and Judge Gowal's dismissal just doesn't expose the executive's interference, but also the judiciary's willing complicity. That's why today's session is crucial. Because without confronting how deeply the judiciary is embedded in the machinery of repression in the interests of the state-corporate mining nexus, there can be no honest reckoning of the ongoing Operation Kagar, the killings, arrests, and sexual violence that is happening now. Our speakers today will take us through this landscape of legalized violence, where courts don't act as checks on power but become part of the counterinsurgency. I now invite Nandini Sundar to speak. Drawing on her decades of legal and political engagement, she will walk us through how the judiciary has enabled state impunity and how this has systematically denied justice to Adivasi communities in Bastar. Thank you, Nandini. Over to you.
Thank you, Latika, and thanks for organizing this, everybody at INSAF, and thank you everybody who's attending. So before I go into the Bastar specific case, I just want to make a couple of general points about the Indian judiciary at the higher levels. Latika has already touched a bit about the district courts, but I'll come to that later. We know that the Indian judiciary does not have a great track record of dealing with mass human rights violations, and that it's not that they're oblivious of these issues. I think that the courts have tried in many cases to respond. For instance, even in 2002, when the NHRC filed, the Supreme Court did ask for cases to be moved out of Gujarat, and that's how we have the Best Bakery verdict. We also have some attempts by the judiciary, for instance, the NPMHR case, the Naga people's case against AFSPA. That was a very disappointing judgment where the Supreme Court just listed do's and don'ts of engagement in the field. But at one level, the Supreme Court has at least listened to some of these cases, whether they've acted, whether they haven't, and what they've done is another matter. Now, the problem with the Supreme Court is not that they are not willing to intervene, but that they are fundamentally hampered by two things. One is their own kind of fear of encroaching on the executive. And so they keep, talking about the separation of powers, and this is not something that we can do. On the other hand, the executive has a fundamental ability to overturn the separation of powers because it's the executive which really clears judicial appointments, even if it's appointed by the collegium. It's the executive which actually decides whether a Supreme Court judgment can be implemented or not implemented. It's the executive which has the police force to, the Supreme Court can order prosecutions, but it's the executive which will have to actually send the police out and do the investigation. And it's extremely easy for governments to stall any judicial action by simply refusing to provide the necessary personnel, the infrastructure, and all of that, right? So when we look at judicial inaction or judicial complicity, it's important to understand that the judiciary operates within a certain force field where it is not the only or even the main actor in delivering justice, right? And in many cases also, the judiciary is dependent on the police to bring cases to it in a variety of issues. Now, over the years, we've seen a change in the direction of the Supreme Court, if it can be called that. And clearly, unlike the US or other Supreme Courts, which are more cohesive here, there is a great deal of polyvocality about the Supreme Court, given that it has so many different benches and each of them speaks with their own voice. So you also have a number of kind of contradictory approaches to any issue. But two things that are very clear in the last couple of years, which have kind of exacerbated. One is the unwillingness to hear what are actually major constitutional issues. And when judgments are given in those cases, they are given in a fashion that favors the government. So we have, Article 370 was heard after 4 years. The CA has still to be heard. Electoral bonds got heard, but then they were not, the investigation did not go back to the beginning, by which time the BJP had already amassed a huge war chest. The second is that it refuses to address political issues as constitutional issues and treats them as merely procedural issues. Now, this is not just something that we've seen in the last decade, but it's accentuated greatly in the last decade. And in the context of mass human rights violations, the most important aspect of what this means, or the most important implication of what this means, is that cases of mass human rights violations are addressed as individual procedural claims, right? So what should be a case where the Supreme Court attributes mass command responsibility. I mean, because India doesn't actually have laws dealing with command responsibility, this is something that human rights activists, lawyers have been asking for a while. You have a number of cases where there are mass killings, and it's extremely difficult in these situations to identify perpetrators. And given that it's impossible to identify, especially, for instance, a case of mass rape or sexual assault by security forces while on an expedition to a village, it's impossible for women to identify who it is. And so that then becomes the basis for saying that nothing further can be done in these cases. So what we see again and again is that what should be treated as a political question, what should be treated as a case of mass command responsibility, is then the onus is then put on the victim to somehow, file. And we know that at the district court level, there are very few cases where people are filing cases asking for justice in cases of false encounters, because it takes a lot to do that, right? You need legal help, you need a government which will not further harass you. I mean, people are scared, right? Because you will then be arrested, attacked further if you take up any issues. So at the district level, what you find is that people are really fighting defensive cases. When family members have been arrested, that's the site of interaction with the judiciary that most ordinary people have. And that site is, again, deeply fraught because, you have, if somebody from your family is arrested, you have to find a lawyer. People haven't even been to their local district headquarters, even alone, go to Jagdalpur or Dantewada or wherever else. They don't speak the same language as the courts. They don't speak Hindi. They don't, so there's a complete disconnect between people's ordinary lives and the way the judicial system operates. And as Lotika said, in these kinds of situations, people stay in jail for years on end before they're finally acquitted, because really there is no evidence. And quite apart from the arrests, what we have in Bastar over the last 2 decades really is a system of picking up people, keeping them in police thanas or Salvajudum camps earlier, or now these CRPF security camps which have come up, not even recording these as arrests, but simply, detaining them and then deciding who will be arrested, who will be released, and so on. So that's at the ground level in terms of how people are engaging with the district court. Now, I just want to sort of go back a bit to our whole experience with Salvajudum over the last 2 decades. So when Salvajudum began in 2005, the state government armed a number of people, mostly surrendered Maoists, Sangam members who were sort of village level operatives of the Maoists, armed them, forced villages to come into so-called relief camps, which were already sort of large-scale prison camps. A large number of people were displaced after their villages were burnt. A large number of people were killed. They were not even shown as encounters. They were simply killed, and there was a lot of rape as well. So in 2007, there were two petitions that were filed. One was by local people who were affected themselves. Kartam Joga, who had been badly beaten up, his whole village was displaced. Misma, during the Salvajadom evacuations. Dudhi Joga from Arlampalli, whose entire village was burnt. And in fact, that was a case where people actually said that Mahendra Karma, who was the Congress face of the Salvajadom, propped up by the BJP administration, was actually, supervising that burning. And Manish Kunjam, who was a former MLA of Sukma and also a leader of the Adivasi Mahasabha. So that was one case. And the second case was filed by me, Ramchandra Guha, and E.S. Sarma, a former civil servant, based on a fact finding that we had done. Now, these two petitions were clubbed together, and I wouldn't say that the judiciary was totally unresponsive. In fact, our experience with the judiciary was at that time quite good. The first case that we had was, we were first before Justice Balakrishnan, who actually understood what was going on, ordered an NHRC investigation. And it was the NHRC which was completely clearly, controlled by the government, then the Congress government in Delhi, which brought out a completely biased report. And in fact, if there is time, I'd just like to share some of the petitions that were submitted to the NHRC in the course of their findings, but which they just refused to hand over, make public, or even include in their report. But at the same time, the report was bad enough for Justice Balakrishnan to then, say that there should be a rehabilitation plan. We were asked to draw up one. Also, we were discussing having a monitoring committee that would then, look at all these cases of deaths. We had compiled a list of about 537 deaths based on petitions that people had handed over to the Adivasi Mahasabha at a mass rally in 2007. So after Justice Balakrishnan retired, we went through a number of other benches before we finally came before Justice Reddy and Justice Nijjar, and we got a landmark judgment which actually banned Salvajadom, banned the use of special police officers in counterinsurgency operations. And we also got directions from the court saying that everybody should be, who had been responsible for human rights violations should be prosecuted. There should be compensation. And the two directions of the court, which were actually implemented by the government, and were one, to stop arming minors or recruiting minors as special police officers, and second, to remove the security forces from schools and to start educational, establishments again. Now, the government did remove the CRPF from the schools which they had been occupying, although by that time, it was not such a great concession to the courts because they had started creating their own CRPF camps. So it wasn't such a hardship to them to remove the security forces. But at any rate, they did remove security forces. And while they did not immediately restore schools for the next 10 years or so, at least that principle was established that schools should not be occupied by security forces. But the Justice Nijjar and Justice Reddy and Justice Nijjar then retired immediately after, Justice Reddy retired immediately after passing this judgment. And obviously, it was meant to be something that future benches would build on in terms of monitoring and ensuring, because the order clearly says, the state government has to report within 6 months. And they also ordered the CBI to investigate into one incident that had happened that year, and so therefore it was sort of fresh in everyone's vision, and it was also the first time that the media had reported on a case as it happened. So between 2000, and so just as soon as the Salvajadom judgment of 2011 came out, the Chhattisgarh government passed an act basically saying that from the date of the judgment, all SPOs would now be regularized into an armed auxiliary force. So they passed an act in order to negate the Supreme Court judgment, but without removing the basis on which the judgment had been passed. So, there are several Supreme Court judgments, precedents which say that if you do legislate and the state is competent to legislate, it is not valid unless it has addressed the constitutional deficiencies which the court has pointed to, which this Chhattisgarh government did not do. So we then filed contempt, and that was not heard and basically we hardly had any hearings of the case till it was finally disposed of this year. And the court again reiterated the idea that there was a great deal of violence, said that this government of Chhattisgarh and the union government should take specific steps to address the victims of violence, to bring about peace and rehabilitation. But they did not specify what these steps were. And above all, they did not give us what we have been in court for all these years, which was somebody to monitor the directions of the court. Because in the face of a government which is completely unwilling to abide by Supreme Court directions, the directions were fine. It was just the fact that they would never be implemented, and the Supreme Court was not willing to put its strength behind demanding that its own directions be implemented. So the Supreme Court's failure in this case was I wouldn't say a failure to recognize the enormity of the issue. They recognize, in judgment after judgment, even in this latest one disposing of our case, how terrible the situation is, how there have been mass-scale human rights violations. But they basically wash their hands off any ability or interest to do anything about it on their own, right? So I think in this case, the Supreme Court's failure has been one of the courage of implementing its own directions. So we have had good directions. The second thing is the enormous delay. Now, even if we had got a monitoring committee after 20 years to identify people, it's not impossible to have done that. Truth and Reconciliation Commissions have done that. But it would just be that much harder to compensate villages when they have already, a mechanism could be devised. It's not at all impossible, but it's just a bit harder when a judgment comes 20 years later. Even if we had got the kind of justice that we wanted, it becomes harder. So there is definitely a sense that judicial delays, and these delays are caused entirely by either the court system themselves or by the counsel for the state asking for adjournments. Our counsel who have fought pro bono all these years have sat in court for over 100 days. The cases have not come up. They go prepared each time and nothing happens. So I would say that insofar as the judicial system is also comprised of the legal profession, again, while there are sections of the legal profession, I would say the majority perhaps, who are really interested in the money and whatever, there is also a significant section which has been fighting for the Constitution. Now, I also just want to, I know we only have 15 minutes each, but I want to read out a note on what has been happening in Raughat as emblematic of what has been happening with environmental cases and mining more generally. And this is a note that has been prepared by Shalini Gera, who has, as part of MATI, which took up the Raughat case, has been representing this issue.
Nandini, you can speak. There is time, so you can speak more.
Okay.
That's okay.
Yeah, thanks. So, so Raughat is in the north of Bastar in the Narayanpur Kanker area, and it's one of the sacred sites where where the Rao is sacred, and people across 300 villages across 4 states, actually, because many of these sites draw Adivasis from different clans coming in across different states. So it's an extremely sacred site, and it's also an extremely important site in terms of biodiversity. And this whole area is governed by the 5th schedule, which means that um, villages have to be asked for their permission under the Panchayat Extension to Scheduled Areas Act if they are to consent to mining. And in fact, any action that takes place on these lands without their consent is illegal. Under the Forest Rights Act also, they're supposed to be asked for consent, and their rights have to be settled before anything can take place. So I'm just going to read now from Shalini's note about the project, where she says that the Raughat iron ore project is owned by the Bhilai Steel Plant. It envisions an iron ore mine over the 7 iron ore blocks, producing 14 million tons of iron ore per year, which would make it one of the largest iron ore mines in India. The mining lease area is 2,028.797 hectares of forest area, which has been awarded to the Steel Authority of India. And while the authorities claim that no village land is included in the mining lease area, the forest land of several neighboring villages is included, and the village of Anjrel lies less than 100 meters from the existing mine. The company has identified 22 villages as lying in the buffer zone, but actually there are at least 10 or 15 more villages that lie in that zone and will be affected by the mining. And now we come to the part about how the courts have been complicit in the mining. And it's quite shocking that it took all this time, I mean, just diverging from this case. It was only recently that the Supreme Court declared the practice of ex post facto environmental clearances illegal. And they set aside as invalid the 2017 Ministry of Environment and Forests approval order and another 2020 notification. Because once you start a project, mining or anything else on on forest land or other kinds of lands, then it's too late to give it permission after everything has been spoiled. And you have to see these sites; they're just huge amounts of devastation of the landscape. So I'm going back to Shalini's note. Despite the fact that there have been continuous protests against mining, and in fact, protests are going on right now as we speak. People have been sitting in Dharna for a month against the railway line. The forestry and environmental clearances were granted to the the mining project in 2009 without obtaining any consent. In 2015, they moved a petition against mining before the Supreme Court, but the Supreme Court then asked them to approach the High Court, which they did straight away. After a few months, the High Court required that it be refiled as a public interest litigation. This was also done, but then in 2017, it was dismissed on the ground of delay, when in fact, it was the court system itself which had caused the delay for more than 3 years. Since 2018, the SLP against this High Court decision has been languishing in the Supreme Court without any substantive hearing. Meanwhile, the project has started in 2021, and most of the forest in phase 1 of the mining, over 3 of the 7 blocks, which was the part closer to the villages, has already been cleared. So it's been lying there in the Supreme Court, and work has been going on while it's still to be heard. The Raughat project envisioned that all their iron ore will be carried through rail, thus minimizing pollution. In fact, this was the primary condition on which the project was cleared. This required the construction of 95 kilometers of railway from Delhi to Raughat. Most of the railway line built in the Antagad block of Kanker goes through heavily forested land. And once again, the rail line was cleared with no thought to the forest rights of the villagers who were affected and without getting their consent. Villages from Patkalbeda moved all local authorities as the JCBs rolled over their fields, for which they were issued occupation rights under the Forest Rights Act. And they also moved the High Court in January 2018, but they have yet to be given any compensation. The forest clearance was also challenged in the National Green Tribunal, but the challenge was dismissed and the appeal has been lying before the Supreme Court since 2019. So the delay in the railway construction allowed the company to say that it needed to then transport by road. And of course, they had not got any permission for that. Again, the villagers challenged this modification before the High Court and again before the NGT, but both cases were dismissed. And the worst part is the High Court has since held that since the railway could not be completed due to the Naxal violence, hence it was permissible to violate villagers' rights. And just to quote from the judgment, the submission of the petitioners could have been appreciated when such conditions of violence do not exist and the law of the land can take effect in normal conditions. If the unnatural events of the Naxal movements intervene to resist the laying down of railway line, then the circumstances also warrant the special measure to be taken in the interests of country. In the instant case, the excavation has been allowed, etc., and the railway line could not be laid down because of the Naxal disturbance. The respondents, that is the company, cannot be driven to a corner for the reason that the unnatural circumstance has arrested to complete the laying down of line until Raughat. To arrest the movement of iron ore in the like nature of conditions would have a larger impact on the economy of the country. Consequently, the balance of convenience would hold the sway in favor of such movement of iron ore in the manner it is being carried out. It appears road to prosperity to all is strewn with sharper thorn. In view of existing circumstances, the dismissal of interim application warrants, and it is accordingly dismissed. And this went to the Supreme Court, and it also refused to intervene. So basically, the High Court is saying that because of Naxalite presence, the company could do whatever it wants, and the entire burden of the devastation would fall on the villagers. And that's just too bad because this is for the national interest. And while they recognize that the villagers have a case, they are unwilling to do anything about it. So as we see it's not as if the judiciary is blind. They make these noises. They're willing to recognize that the fundamental rights of villagers, of the environment are being violated. But in the circumstances, they just don't have the, shall I say, courage to actually take a stand. And in fact, even if they had the courage, it's the government which is really at fault because they are more than happy to overturn, neglect, refuse to implement any order of the court that goes against them. So I'll stop at that.
Thank you so much, Nandini, for laying out these nuances really in the inaction of the courts as you have done to explain how even if it wants to, it doesn't have the courage, or then the government is, and things around the command accountability as well. So thank you so much for your contribution today regarding this courts and state violence in Bastar. I will now request Megha to speak. Megha will share how the judicial infrastructure, including courts processes, laws, and prisons, are deployed to neutralize indigenous political assertion in East Central India. By discussing instances of wrongful incarceration and wrongful prosecution faced by people either belonging to or sympathizing with, or those perceived to be sympathizing with the CPI Maoist Party or the Pathalgadi movement in Jharkhand, she will ask what the judiciary could have done in upholding the constitutional rights of Adivasis and what it did not do so. She will discuss how the judicial infrastructure becomes an essential ingredient of the state's strategy in the region to complement security operations in countering any indigenous assertion towards autonomy and land rights. Over to you, Megha.
Thank you, Latika, for the introduction, and thank you Insaf and London Money Network for organizing this web series. And it was also very insightful to hear Dr. Nandini Sundar speak about the gaps in judicial action that we are all hoping for in the context of Adivasi lives. Let me begin my segment by reminding all of us that just 10 days before this webinar, on June 9th, was Birsa Munda's 125th death anniversary. Birsa died on June 9, 1900 in Ranchi jail. The colonial rulers had imprisoned him for leading the Ulgulan and Adivasi movement, demanding autonomy over their lands in a region which is administratively now part of the state of Jharkhand. Cut to the present day, and we will soon be observing Adivasi rights activist Father Stan Swami's death as an under trial prisoner on July 5th, 2021. Stan believed that he was penalized for seeking the release of Adivasi under trial prisoners languishing in Jharkhand's prisons, as also consistently advocating for their land rights. What we saw back then during the colonial rule is also what we see today in Adivasi regions of East Central India. We see today the deployment of judicial processes as an essential element of the state's strategy aimed at neutralizing indigenous political assertion, an assertion toward protecting their autonomy and their lands. To understand this issue better, let me start by quoting from a publicly available official source on the approach of the state in the region we are discussing, and I'll request Nandita to come to the next slide. So I'm quoting from the Bureau of Police Research Development newsletter from 2024. And I quote, "The Union government has been tackling the challenge of left-wing extremism on three fronts: development, no, not this one, the previous one. The Union government has been tackling the challenge of left-wing extremism on three fronts: development, security operation, and prosecution. It is the working of this third front, prosecution, which I will discuss today with you all. Specifically, I will explore, and as Lotika has already shared with you all, how the judicial infrastructure, including court processes, laws, and prisons, become equally important ingredients of the state's strategy in this region to complement ongoing security operations. I will discuss some of the characteristics of this infrastructure deployed in the context of indigenous political assertion in Jharkhand, by taking instances of wrongful incarceration and wrongful prosecution faced by the people belonging to or sympathizing with or perceived to be sympathizing with the Communist Party of India Maoist, or as also the Pathalgadi movement in Jharkhand. I will ask what the judiciary could have done in upholding the constitutional rights of Adivasis, what it did not do, and ponder over possible reasons. Before I delve deeper, let me also make it clear that this talk is not about the merits or demerits of a certain political movement or my opinion of them. I am fully cognizant of the various critiques of the movement organized by the CPI Maoists, as also the Pathalgadi movement. However, this talk focuses on the constitutional expectations of our judicial institutions when faced with a difficult socio-political terrain. That there is an overall failure of the lower judiciary in being effective gatekeepers to wrongful incarceration and prosecution was flagged in recent times by a public interest litigation filed by late Father Stan Swamy before the Jharkhand High Court at Ranchi. The petition prayed for a declaration that the prolonged incarceration of under trial prisoners due to systemic reasons or for no fault of their own, especially those belonging to marginalized communities in the state, is violative of Article 21, that is right to life, of India's Constitution. The PIL itself was based located in Namkum, where fathers.
Oh, we're losing your voice a bit, Megha.
I'm sorry?
Megha, can you hear me?
Yes, I can hear you.
Now you're there. Sorry, we lost you a bit in between. So yeah, just if you could repeat that a little bit, last bit.
Yes. Now, on the next slide, please. The PIL was based on a research study conducted by the Bagaicha Research and Action Center located in Namkum, where Father Stan used to live and work. Published in February 2016, the study's title is "Deprived of Rights Over Natural Resources, Impoverished Adivasis Get Prison, a Study of Under Trials in Jharkhand." The study collated data on 102 alleged Naxalite under trials from 18 districts of Jharkhand. The research team collected primary data through fieldwork between March and June 2015. They collected case histories through in-depth personal interviews and a semi-structured questionnaire. They filed RTIs in all jails of Jharkhand to get data of on-trial prisoners lodged under UAPA, Unlawful Activities Prevention Act, or Section 17 of the CLA, Criminal Law Amendment Act, both of which criminalize unlawful associations, although they did not receive very many responses to those RTIs. The team also relied on a bunch of secondary resources, like collecting information from lawyers and activists working with alleged Naxalite UTPs. The team further updated this data by doing more interviews in 2016 and 17. The research found that there was a gross misuse of the criminal legal system in keeping Adivasis and other marginalized people incarcerated on the allegations of being one or supporting an Naxalite. It brought to fore that large numbers of people are being named and arrested in multiple cases with little accountability. Bail was a near impossibility due to the multiplicity of cases foisted upon them, the invocation of laws like the UAPA, which has a higher threshold for bail, and or people's inability to obtain effective legal aid. It found that people were languishing behind bars for long durations due to their cases being held up at different stages of the criminal trial. In West Singhbhum district, for instance, which has witnessed CPI Maoist presence over many years and is still classified as the lone LWE district in Jharkhand as per an official press release dated 1st April 2025, these researchers found long delays in criminal cases and people wrongfully incarcerated in the following manner. Nandita? There were several cases found pending at the pre-trial stage of cognizance. This is the stage where the court looks at the police investigation report and decides whether there is an offense committed into which a criminal proceeding should be initiated. Cases were found to be held up for many months and in some cases years at this stage, some cases years at this stage, primarily for want of sanction for prosecution in cases involving offenses like UAPA, Arms Act, or Explosive Substances Act. For context, if the police files a charge sheet involving certain UAPA offenses, Section 45 of UAPA bars the court from taking cognizance unless the central government grants sanction for prosecution. There is a strict 14-day timeline for the sanction process, but ironically, in the case of these prisoners, this law meant to protect from wrongful prosecution became the reason for their prolonged incarceration. There was another set of cases which were found pending at the stage of charge framing. This is the stage when court decides the specific offenses for which specific accused persons should be tried. These cases were found pending mainly because of non-appearance of co-accused who were either absconding or dead or incarcerated in other district jails and not being produced. And finally, there was a third set of prisoner cases pending at the stage of evidence, some of which were even pending for more than 5 years. This pendency was because of non-appearances of witnesses or the co-accused or just a long list of witnesses to be examined. For instance, there was a case where the first informant was a paramilitary personnel and was posted in another state and hadn't been able to come for his deposition, due to which the trial remained held up. Now, the burdens cast by these delayed processes on people is reflected in the swelling prison populations. Nandita? The occupancy rate of Chaibasa district jail as on December 15, 2023 was 156, and 93% of its prisoners on that date were under trials. Similar is the state of other so-called LWE districts in the state. To give another example, Latehar, one of the 2 Jharkhand districts where the Bura Pahar region saw Operation Octopus in November 2022, also has a very high occupancy rate of 208.57%, and 98.9% of its prisoners are under trial prisoners. Over the 10-year period from 2013 to 2022, Nandita, over the 10-year period from 2013 to 2022, of which data from the Prison Statistics of India is available, Jharkhand's prison occupancy rate has averaged at 119, those of central jails 105, district jails, and this is the more important one, 157, and sub jails 97. Now, how did the lower judiciary contribute towards this project of what we may call mass criminalization and mass incarceration of Adivasis in Jharkhand? In this conflict-ridden terrain, what could the magistrates have done to uphold the constitutional right to life, including the right to a fair and speedy trial? For cases delayed at the cognizance stage because of want of sanction, instead of waiting for the authorities to complete sanction proceedings, they ought to have proceeded with the case qua other offenses, especially given the fact that the under trial was in custody and offenses like UAPA attract a higher threshold for bail. I must add here that high courts in the country have discharged accused persons under UAPA if sanction proceedings were found to be irregular. For cases pending at the charge framing stage, delayed due to non-appearance of co-accused persons who are either absconding or not being produced, they could split trials under Section 299 CRPC or now Section 335 of the BNSS and proceed to record evidence in the absence of the co-accused for the sake of those in custody. And for cases pending at the evidence stage due to witness absence, they could issue warrants under Chapter 6 of the BNSS for ensuring presence of witnesses if they are absolutely essential for trial. The recent amendments to the Code of Criminal Procedure have now introduced a new provision, Section 336 of the BNSS, Bharatiya Nagrik Suraksha Samhita, which permits successors of public servants to depose if their predecessor is unavailable so that the trial is not held up. Within the criminal legal system in India, the magistrates are the first line of defense against constitutional violations. At different stages of a criminal case, as we just saw, they have the power to make decisions about the need for incarceration, the need for prosecution. They are expected to look for signs of custodial police violence or a forced confession and oversee a fair and speedy trial. In this way, it is expected of them to ensure that constitutional rights of the accused in criminal cases guaranteed under Article 20 and 21 of the Constitution are protected. However, we have found the lower judiciary unable to exercise effective oversight and accountability in the region. This mass criminalization and incarceration of Adivasis was also seen during the Pathalgadi movement. In 2017, by way of backdrop, the Raghuvar Das government organized Momentum Jharkhand, a global investor summit aimed to establish Jharkhand as a premier investment destination for both Indian and foreign investors. The summit reportedly attracted investment commitments around of amounting to INR 3 lakh crore, which with the signing of 210 MOUs in the first 2 days itself. The government transferred around 2.1 million acres of uncultivated and common lands to industrial land banks, and also attempted to amend the Chota Nagpur Tenancy Act 1908, which prevents non-alienation of Adivasi lands towards non-Adivasis. In response, Munda Adivasis in Khunti district initiated a protest relying on a customary practice called Sasandiri. This is a Mundari practice in which they install stones at burial grounds to affirm land ownership of their Khund Khatidar ancestors, or those original settlers who first cleared the lands and their clans. During the Pathalgadi movement, Adivasis opposed land alienation attempts by the government by erecting large stone slabs at village entrances, having inscriptions of those laws which assure Adivasi autonomy over their lands. They prevented government functionaries from entering villages and rejected government welfare services. This was another Adivasi movement asserting sovereignty over lands, laws, and governance. But this movement too faced a crackdown by the misuse of the criminal legal machinery. Nandita? According to data published by activist Gladson Dungdung, as obtained from the government of Jharkhand and scroll.in, 11,321 people faced criminal cases for their alleged involvement in Pathalgadi. There were a total of 30 cases filed across 3 districts, Khunti, Saraikela, Kharsawa, and West Singhbum, of which 21 involved the offense of sedition. 381 people named in these cases, and others, 10,940, were unnamed. Police submitted charge sheets against 182 persons in these cases, and 115 were jailed. Ultimately, even though the Hemant Soren government withdrew all but 5 cases by the end of December 2023, but not before those 115 people suffered incarceration, those 381 named persons scrambled for legal help, and thousands of others who, along with their family members, who went through days of psychological stress and fear of having to face criminal proceedings. A report published in the Outlook, Nandita, by Mohammad Asghar Khan produces testimonies of people who were jailed during the Pathalgadi movement. 45-year-old Powell Tutti said, "The case was withdrawn on the order of the government after 2.5 years. Neither was I getting bail, and nor did I have any money to get bail. I had to mortgage my land for a mere 95,000. Till now, I have not been able to get my land back." 50-year-old Sukra Munda from Kuti, who had 2 cases on him, shared about the inhumane prison conditions. "I was kept inside the 12 feet by 0.7 feet cell. I used to sleep, eat inside it, as well as use it as a washroom. I came out after a month and was again put inside it. I stayed here for 2.5 years. Sukram's family also had to sell their cattle, mortgage land, exhausted their savings of rupees 18,000 rupees, and his elder son had to drop out of school at 10th grade. There is no word or any measure of compensation for the wrongful incarceration and prosecution, or the inhumane jail conditions, or the consequences borne by their families for asserting their constitutionally guaranteed right to autonomy over their lands. What I also want to draw your attention to is the number of persons who face the threat of criminal proceedings, 11,321. Please reflect on this number juxtaposed with the sheer incapacity of the legal system to even cater to this kind of mass criminalization. In Khunti, there were 23 cases out of 30, in which 340 persons were named, while 10,640 were unnamed accused. There is only one sub-jail in Khunti district with a capacity of 500 prisoners, and it has an occupancy rate of 110 already. There are 6 people in the lower judiciary in Khunti, 4 of whom handle both civil and criminal rosters. As per a 2022 Press Information Bureau release, the ratio of pending cases to judges in district and subordinate courts in Jharkhand is 982, which means at least 43 cases per day if they have to hear them on a monthly basis. Already a lot for an 8-hour work shift and a judge handling both civil and criminal rosters. Further, according to the BPRD, Bureau of Police Research Development, the actual strength of the police force as against those sanctioned in Jharkhand as on 1st January 2023 is only about 73%. In Khunti itself, there are just 13 police stations, and there is no way the existing strength of police personnel would be able to match the needed capacity to even interrogate and record statements of 10,000 people. So when the criminal legal system does not have the capacity to attend to these numbers, one wonders, why would the police even file such cases? Why is it that the judicial magistrates are unable to live up to the function of protecting constitutional rights during remand hearings, cognizance hearings, and at different stages of a criminal trial in a conflicted terrain? Is it even possible, one asks, to live up to this function? What explains the situation is the prosecution prong of the state's strategy that I highlighted at the start of my talk. This strategy of prosecution involving mass incarceration and mass criminalization in this region is nothing but a form of what is known as lawfare, or using law as a weapon of war. In tackling with quote unquote LWE, the Indian state actors seem to be inspired by this concept advanced in recent times by a retired US military officer, Major General Charles Dunlop Jr. According to him, lawfare is the use of law as a means of accomplishing what might otherwise require the application of traditional military force. Before the current spate of encounters and security operations intensified in the region, lawfare has been at play for many years, attempting to neutralize Adivasi adversaries through criminalization and incarceration. Use of the sword of court processes, laws, and the prisons in this region must also be viewed as a form of psychological warfare tactics played out slowly over an elongated period of time to counter indigenous sovereignty movements. This warfare tactic is geared toward demoralizing and instilling fear among people who either belong to or sympathize with or are perceived to be sympathizers of Adivasi movements asserting political sovereignty. When people face or are even confronted with the threat of facing long-drawn, arduous processes of a system that they are not familiar with, any possibility of them supporting or participating in a political assertion becomes an uphill battle. And by not exercising effective oversight, whether out of lack of diligence or out of ideological inclinations, out of fear or perhaps even due to non-feasibility, as we have seen, the lower judiciary in this region becomes a means to an end. It enables the state to use the judicial infrastructure as a means to lawfare and as a tool for psychological warfare, unleashed through mass incarceration and mass criminalization. As I conclude, I am reminded of a court scene from May 16, 1900, Nandita, from Jungle Ke Davedar, a novel written by Mahashweta Devi on the life and struggles of Birsa Munda. This was a bail hearing conversation between the magistrate and barrister Jacob, who represented Birsa and 92 other Adivasis jailed for starting Ul Gulan. The scene accurately depicts what has been one of the themes of our discussion today, the lack of oversight by magistrates, leading to wrongful incarceration and prosecution in East Central India. In the scene, the magistrate is unmoved to find a copy of an order on file by which bail had already been granted to the concerned prisoners, but which had not been conveyed to them. Upon knowing that they might all be released, the police officer instantly makes a request for filing additional non-bailable charges against them and seeks a day's time. Barrister Jacob opposes, but the magistrate is unmoved. That was May 16, 1900. Such is the story of Jharkhand and adjoining states, even today. Thank you.
रिकॉर्ड में देख रहा हूं कि मेरे पहले के मैजिस्ट्रेट ने 7वीं अप्रैल को एक ऑर्डर फाइल पर लिखा था जिसमें 100 रुपए देने पर उसकी जमानत का अधिकार मंजूर कर लिया गया था, उसका और बाकी अभियुक्तों का भी।
पूछ सकता हूँ कि इस ऑर्डर की बात उन लोगों को भी बतलाई गई है या नहीं?
यह मुझे नहीं मालूम।
रिकॉर्ड में तो यह बात लिखी गई होगी।
नहीं,
यह तो ताज्जुब की बात है।
ये मामले भी ताज्जुब के ही हैं।
बहुत ताज्जुब के। आप क्या जमानत का ऑर्डर कंफर्म कर रहे हैं?
हुजूर, मैं एक अर्जी पेश कर रहा हूँ। मेरी प्रार्थना, कैदियों में 67 लोगों के विरुद्ध हत्या में सहायता और दूसरे चार्ज भी लगाए जाएंगे।
यह क्या अब? यह तो बहुत अन्याय है। 7वीं अप्रैल को अगर मेरे मुवक्किलों को मालूम हो जाता कि उन्हें जमानत मिल सकती है, तो वे आज तक जेल में नहीं रहते। उसके सिवा इनके विरुद्ध चार्ज लगाने में पुलिस को 5 महीने और लग गए। यह अन्याय शोचनीय है।
हुजूर, अगर कल तक वक्त दोगे तो और लोगों के विरुद्ध शायद एक चार्ज लगा सकूंगा।
क्या कहते हैं मिस्टर जेकब?
मैं सिर्फ यही कहूंगा कि ये सब कार्यवाही मुझे ताज्जुब में डाल रही है। जो लोग शायद बिल्कुल बेकसूर हैं, उनके खिलाफ चार्ज लगाने तक में 5 महीने हो गए। वे जेल में पड़े सड़ रहे हैं। और भी ताज्जुब की बात यह हो रही है कि पुलिस अब अर्जी दे रही है दूसरों के खिलाफ चार्ज बनाने के लिए 1 दिन का वक्त और चाहिए।
वे 66 आदमी तो किसी तरह जमानत पाएंगे ही नहीं। औरों के बारे में इंस्पेक्टर ने क्या कहा, वह आपने सुन ही लिया है।
उनके खिलाफ इस वक्त कोई भी चार्ज नहीं है। उन्हें आपने कैसे हिरासत में डाल रखा है? मेरा कहना है कानून का बहुत बड़ा अपमान है, बहुत बड़ा अपमान। यहाँ 217 लोग प्रायः 5 महीने से कैद में हैं। किस कसूर में यह उन्हें कभी बतलाया नहीं गया। अभी आज ही अचानक एक पुलिस की अर्जी के आधार पर उन पर एक नया और ऐसा अभियोग लगाया जा रहा है ताकि उन्हें जमानत भी ना मिल सके। इन अभागों में 93 लोग मेरे मुवक्किल हैं, लेकिन कितनी ज्यादा बेइंसाफी हो रही है। उनमें 67 लोगों को आज ही जिस अपराध में अभियुक्त बनाया गया उसे अगर सही मान भी ले, फिर भी प्रार्थना है उनके विरुद्ध क्या क्या गवाही और सबूत है वे मुझे बतलाए जाए, जिससे कि उन्हें जमानत पर छुड़ाने के लिए मैं अपील कर सकूं।
पुलिस की अर्जी पाकर ही मैंने हुक्म दे दिया है। वे जो 67 लोग अभियुक्त हैं, उन्हें जमानत नहीं मिलेगी। बाकी जो रहे, उनके नाम, उनके गांव के नाम, सब ब्यौरा मिलने के बाद ही उनकी जमानत की बात पर सोच सकूंगा।
लेकिन सम्मानित महोदय, उन 67 लोगों की रिहाई के बारे में भी मेरी बात आपको सुननी ही होगी, जिन्हें कि अभी अभी जमानत ना मिल सकने वाले अपराध में अभियुक्त बनाया गया है।
अरे बताया ना कि मैंने उनके बारे में हुक्म जारी कर दिया है। और लोगों के नाम, गांव, पता वगैरह मुझे दें। उन सब लोगों के नाम प्राय एक से ही तो होते हैं।
गांव के नाम मिलने में कुछ वक्त लगेगा, वह काम चलता रहेगा, लेकिन मैं फिर कह रहा हूँ, जिन जिन 67 लोगों के को पुलिस ने अभी अभी चार्ज किया है, उनकी जमानत के बारे में मेरी बात आपको सुननी ही पड़ेगी।
उसके बारे में मैं निर्णय दे चुका हूँ।
I think this was just a scene from Jungle Ke Davedar, and it was so representative of the situation that we are discussing today. So I thought it would be nice to go back to it. Thank you.
Yes, thank you so much, Megha, for sharing the searing accounts of how the judiciary is used as a tool of subjugation in these Adivasi regions of Jharkhand, which is neighboring Chhattisgarh, of course, and where we were earlier talking of Bastar as well. And also for that, I think the Mahashweta Devi's play, because it kind of shows, and in everything that you both have also told us today, that everything the Adivasis are experiencing today is very much intertwined to this long history of coloniality in India. That there was British colonialism, but that colonialism has not left us. So thank you so much for that. Now I would request if there are any questions for our Nandini or Megha.
Yeah, there are just a couple of questions. This is for Nandini. What can we do to make the Supreme Court intervene in the ongoing extrajudicial killings in the name of Operation Kagar?
Well, I suppose one can go to the court. It really depends, I think, on what kind of bench you get. Unfortunately, Justice Pardiwala, for instance, wanted to jail Himanshu and actually did jail Tista and Mr. Sri Kumar for taking up public interest litigation. So it really depends, but I think given that one has to cover all bases, one could also go to the courts. I don't know what can be made to, I really can't answer that question.
Yeah, it's certainly, with everything we've heard, a question that needs asking, but very difficult to answer. Yeah, and did you said you had another question, Nandita? If you do that, and then there is one with me as well. Yeah.
Okay. If we reduce the court negligence or violence to individuals' virtues, including courage, then how can we fight for a just jurisdiction at the systemic level?
Okay, that I will answer, because I think we're saying it's not reducing it to courage, because we have systemic solutions to all of these. It's not like the laws don't exist or they don't, people don't know what has to be done, right? So there is clearly a systemic problem of complicity across the board. I mean, we're seeing that in universities where long-standing conventions about everything are being rapidly overturned. We're seeing that in the way the media is reporting. We're seeing that in the judiciary. So I'm not singling out the judiciary for its lack of courage. The problem is a systemic one where existing conventions have been overturned, and the fact of overturning these conventions with such ease is what is being celebrated in this new world, right? So it's the ability for, Modi to just overturn 370, to take away equal citizenship, and that lawlessness is now what is celebrated. I think that is the systemic problem, actually. And it's the way the whole, it's connected to to a lot of things, like information that's coming to people from the media, the way that, so it's not a question of individual members of the judiciary not taking up cases. It's not that at all. But on the other hand, there is no solution to that simple act of resisting the lack of, there is no alternative to resisting the systematic violation, even though courage is not the systemic answer to what is happening, right?
Yeah, thank you. I think that's really helpful. I also want to extend this question to Megha, if that's okay, that considering what Nandini has said, that, and thank you for bringing in the broader context in which we are seeing this. I mean, certainly Adivasis are not the only people who are going through various forms of repression, but at the same time, coming back to them and thinking of, again, you started with 1900. And like Nandini said, from then on to now, we've also had some very important laws passed, which actually validate Adivasi right to self-governance. But at the same time, as the in your own presentation, which was mostly post 2014, could you just say what you feel is this trajectory? Is there a trajectory you've seen in which this has come to what we are seeing now?
Well, in my research today, I actually just researched since the last 10 years, actually. And in that, clearly we can see, the just the occupancy rates of prisons, or the percentage of under trials not going down, and constantly also seeing how the state functionaries, especially IG Sundarat speaking on the issue, there various prongs of strategies, development, security, and prosecution, and a psychological warfare happening on the ground. I feel that's the pattern that I have observed increasingly over the past decade. Because that's how you weaken any political movement, in a slow manner. You kind of convert people, or bring them to your side, and those who do not want to have to be incarcerated, or have to go through the travails of the criminal legal system. So that's the pattern that I see over the last decade, clearly. I'm not very optimistic about not discounting the fact that there have been a lot of struggles behind all the land-related laws that we have, but I'm not very optimistic about how they are playing out on the ground at the moment, because that's the reason why we have a Pathalgadi coming up, or movements not dying down. So yeah.
And as Nandini said, Raughat, the protest is happening as we're talking here. Thank you for that. So there's another question, which I think it was addressed to Nandini, but I think even Megha, if you would like to also comment after Nandini. It says, not undermining the tremendous work done by civil rights activists and progressive lawyers such as yourself. At the end of the day, only a small minority of cases are properly heard in a just and timely manner, barely scratching the surface. Justice delayed being justice denied. Compensation for wrongful incarceration is almost never heard, which itself is unjust. So how does one maintain the determination to fight in the courts when the judicial system is increasingly being politicized against the people?
Megha, you want to answer that? Since you're the lawyer, I'm not.
No, please go ahead, Dr. Nandini. I'll answer after you.
So I don't know about determination to fight anything and how that can be maintained, but I just want to add to something that Megha had said, which is that this is at one level an older problem. There was an article by Vasudha Dagambar on Saharia encounters, Saharias in Jharkhand, a particularly vulnerable tribal group. And it wasn't an Naxalite-related case. It was just an ordinary case of some murder of a contractor or something. And so the title of the essay is Prisoner at the Bar, Are You Rich or Poor? And in a way that encapsulates, Adivasi encounters, Dalits, Muslims with the legal system, that it is ultimately a question of having the resources to come to court. And when we talk about, how to make the courts here, actually, if you look at Nick Robinson had done this study of how many cases PILs come to. Actually, PILs are only like 1% of the overall docket of the Supreme Court, or very little. And if you look at the cases that do come to the Supreme Court, most of them are from neighboring states, very few from further away, because you need, it's harder to get lawyers to come from there, or for the petitioners, litigants themselves to come. So the whole judicial system is, Rajiv Dhawan had also, had sort of written this while ago, which is really insightful, that it's actually a strange system because it's based on a public good which is put into motion by a private economy. So the litigants and the lawyers are part of a private system, and they are the ones pushing the direction of this public system. So it's only when cases come to court that the judiciary, the higher judiciary, will act. And as for the lower courts, as I said, all the cases there are defensive. People are just fighting to save themselves from arrests or save themselves from in this kind of situation, right? So they don't have the kind of wherewithal to push cases at the lower judiciary. And the inaction of the lower judiciary really depends on the signals also being sent by the higher judiciary. If, Justice Bela Trivedi refuses to grant bail, has a special hearing on Saturday to take away people's freedom, sits on, even though Mahesh Raut had been acquitted, had been given bail, he's been in jail for 2 years after being given bail by the High Court, just because Bela Trivedi had sat on it. So, these are just such shameful signals being sent by the Supreme Court, that one can't really blame the lower judiciary, because they are basically, like all lower bureaucracy creatures. It's sort of the banality of evil in their case, or in the case of all administrative staff who are complicit in all of this, right? So I think we can't really blame. It's the police, it's the chief ministers who are responsible, it's the IGPs, the DGs, the people who are leading this, who are creating the, atmosphere for all these. It's the incentivization policy where you have huge rewards for Naxalites, which create the corruption in the whole system. It's not your little person. Of course, that person is killing and being brutal and all of that. So they need to be arrested, but far more, you need the top people to be given some kind of exemplary punishment.
The issue you mentioned in your talk about command accountability, it comes back to that, and it's something we need to probably explore more. Thank you so much. Megha, would you like to?
Yeah, no, I would defer there. I would say it has to be at the lower levels also, and I haven't seen that. I don't think there can be one center for any kind of possible change. I feel magistrates, researchers, activists, all of them have to bring out jail testimonies, prisoners' testimonies. They have to talk about encounter deaths or custody deaths, and bring accountability to that. Mr. Vikas Tiwari, a journalist in Bastar, goes around encounter sites as if it's a field stay. We don't know if magistrates have really visited those sites to collect evidences, but a journalist like him holds on to articles from the field site freely. So there has to be some accountability that we have to demand of custody deaths, of encounters, of prisoners' testimonies. Magistrates, I understand that there is an atmosphere of fear even at the lower judiciary level, but what else can we then expect of institutions? We can stop expecting anything from them. They have to come together and say that they are being pressurized into not doing their job. So I would definitely think that I have more. My eyes are more on the lower judiciary and in the field more than the Supreme Court, the way the things function in
But
the judiciary.
sorry, can I just respond? It's not a question of the Supreme Court or the lower judiciary. It's the question of who's acting to make them accountable, right? And so that needs a whole ecosystem of other people, as you said, journalists, civil rights activists, lawyers, at whichever level, the local level or the Supreme Court level, because it is ultimately what cases come to the judiciary and what pushes them. They don't act on their own to do anything, really. And they should be doing things, magistrates, but it's a systemic problem, and the way is to kind of push them, not it's neither this or that.
Yeah.
Thank you both.
all.
And
We have another question. Sorry,
okay.
Radhika.
Yeah, I just wanted to make one point, and then yes, please that, and we can take one more question. So I wanted to, what you mentioned about this, the court being far and most of the cases coming from nearby, but that's also, I think, a really important point, because even when this system, this what we call now the modern system, started in British colonial times, we have inherited that system to some extent. This was an issue always, at least in the Adivasi regions, that you had to travel very far distances to go to a court. And again, that's always been a problem, I think, for local people. That's my understanding, at least. And something we also have to keep in mind, perhaps even for lower courts, it could be at a distance, isn't it? Still from those villages in the forests and the things. Yeah, Nandita.
Yeah, there are a few questions, so I'll maybe just collate all of them, and then you guys can comment on them. So people are asking if there has been a shift in how people's movements are approaching the court system. Is there a shift away from ground movements in approaching courts as a way of relief? Another question is on how to express solidarity. This is what we are seeing throughout India. Do we need more people like you two to be in legal training? What is the role of public pedagogy? And what are the resources we can rely on? And another person has asked Nandini about the judgment that you mentioned, and to unpack a bit about the violence in the language of the judgment. Nandini, if you can start, and then Megha, if you can also add your thoughts on that. Thank you.
So I think definitely, given the way the courts have been behaving over the last decade, and the degree of kind of degree to which they have allowed the executive to get away with everything, people are much more wary of filing cases, social movements. People are, and it's become increasingly difficult to do that, I think, to file cases. But we also don't have a sense of how many cases there were, like, over the decades which did not get filed, because it's, we only know the cases that did come to court. We don't know all the cases that didn't come to court, all the kind of egregious massacres and things which may have just happened quietly, or especially environmental violations, which were not able to come because at that time there was not even a law for that kind of thing. So yes, definitely cases have come down, as far as I can tell. Secondly, I'm not a lawyer, so yes, we do need lots. I mean, we're constantly relying on lawyers for everything all the time. Students are also getting arrested, faculty are getting suspended. So it's like, at every level, everybody's relying on lawyers, leave alone, such horrible cases as in Bastar. So yes, it would be really nice if more lawyers joined the legal, like more people joined the legal profession and took up these kinds of cases, especially in places like Bastar or Jharkhand, where really people have no access to the law. And there's just so much to do. And the third thing about the violence of the judgment, yes, that you'll have to ask Shalini for more details. It is an extreme, from what I can gather. Just the refusal to hear Raughat is not just very violent to human beings, but very violent to the environment. It's actually going to cause a huge amount of devastation. This actually take away the waters of a large area, destroy endangered species. So judicial inaction in this case is a violent, is leading to a very violent outcome, or enhancing the violence of that outcome.
Before Megha, you come in, can I just ask here, because it's in some ways linked to what you're saying just now, even for that Salva Judham statement, Nandini, the judgment, Nandini, I mean, now that they have dismissed it, what are the, how are the, what do you say to the people who saw killings, burnings, rapes, who experienced these things in their families, themselves? I mean, what messages these judgments giving to those communities? I mean, I'm asking you to speak on behalf, say, but if you understand what I mean.
I can't speak on their behalf
Yeah.
because many of them are not even aware that, I mean, nobody's been hoping for anything from the courts, really, in the sense that
Okay.
people whose houses were burnt have gone back and rebuilt the houses themselves. They didn't even hope for anything from the government in terms of immediate compensation, because they knew that wasn't going to happen, right? So obviously there is a sense of anger, injustice, but in a lot of cases, like, so in this Tadmetla Timapura Morpalli case, 3 villages were burnt in 2011. 3 women were raped, 3 people were killed. So the women have moved on. What else can they do? Like, in all these cases, there is no justice coming. There's no expectation of any justice coming. So people are just putting their lives together as best as they can. And so if you never had any hope from the system, I don't know if that's better or worse than to have had hope and know that it's not going to deliver what you want. I mean, the court has always been alien. So why? I mean, it's only the court and the lawyers who really expect it to work. It's like, who does the dominant ideology influence? Those who are dominant, not the people who never really had any expectations. I mean, there's a debate about that in terms of how much hegemony the court employs, but certainly the people who most think that the Supreme Court or the courts in general are delivering justice are the judges themselves.
Thank you. I think that answer did bring out a lot of things and added to what we've already discussed, and it should keep in mind as to the various nuances of how there is absolutely no recourse for justice for a large majority of the Indian population, and it starts very much with the Adivasis in central and eastern India. Megha, would you like to add anything?
Yeah, I was just going to say that when I think of Jharkhand, at least, there has been a systematic destruction of the civil society, so to say. There was a sedition case, for instance, in the Pathalgadi movement, where all human rights defenders in the state of Jharkhand had some case or the other. There was the Kochang rape case, which kind of sent a message to the Christian missionaries, Catholic missionaries working in the state in a large way. Then the Bhima Koregaon case itself, framing Stan Swamy in the case itself, filing a petition itself in court, drew him to Maharashtra. For the sedition case, he also faced Section 82 proceedings, which is that you're absconding while he was always in his house in Bagaicha. All the other organizations in Jharkhand have been either banned or systematically, legal action has been taken on them. And if you listen to what Sundaraj has to say in a recent interview to Organizer Weekly, which is an RSS mouthpiece, he considers all of these activities as the united front. I mean, if you paint everything with this brush of, you are all Maoists, then basically your act, and he says openly that, our strategy is legal action against the united front. So if you consider every civil society act as in the realm of banned activity, then you're basically strategically demolishing anything that can even go to courts. So I mean, so I think that pattern has to be identified, that there has been a systematic destruction of anyone who can even approach courts in Jharkhand, at least. And from there, perhaps we can have some thinking around what can be done.
Sorry, did you have anything else to add there?
Yeah,
I mean, Ajit, this what you said, Sundaraj was saying, I mean, we've heard Ajit Doval saying before that at a higher level. So yeah, absolutely. Any other comment you'd like to make? Otherwise, we've reached 1.5 hours. So I'll then just make some closing remarks.
And we have Justice Parthiwala saying that litigation is actually taking away from the efforts of the forces too.
There we are. With that, I'm afraid we're going to have to end the session today. And I thank everyone who joined us, and Nandini and Megha for all these, deep insights that you have shared, and which have deepened our own understanding of how the courts in India are instruments of state power today, and what has led to that to some extent. So thank you so much for giving us your time and your insights. And as in our next session, which is, before I come to that, I did want to say, as you've also heard that, I'm just going back to the incidents that even I raised in Bastar in the beginning, that they are not isolated past incidents. As you can see, it reflects a structural design that continues to operate in exactly the same way today. And these courts in Bastar, in Jharkhand, across Adivasi regions remain deeply embedded in the machinery of state repression, sustaining the same patterns of prolonged incarceration, denial of bail, and judicial complicity, and the higher courts continue to look away, refusing to hold the state accountable or to defend the rights and dignity of the Adivasi people. So that was just a summary of everything we have discussed. In our next session, which is scheduled for the second week of July, we will turn to the question of narrative, which did come up and was touched on today, certainly because of the way the framing is done, that everybody is Naxalite, and so we want to look at that in more detail as to how the Indian state has systematically shaped public perception of resistance movements in Adivasi regions. And in Bastar, we will go into it through the angle of Bastar again. We will examine how, in the absence of nuance or truth, the state has constructed a binary of national interest versus internal threat, a framework that demonizes and dehumanizes all forms of resistance in the region, portrays opposition to state and corporate plunder as a threat to national development, with the aim of manipulating the public to cheer on the incarceration, disappearance, and killing of their fellow citizens. We'll announce more details of this shortly. In the meantime, we encourage you to stay connected, to share our previous webinars, and to engage with our forthcoming multimedia educational materials, which we will produce from this series, and we will be in touch and inform you about. But most importantly, we urge you to build global solidarity, organize where you are, speak about this wherever you can, against that so-called deadline that is in truth a death sentence declared by the Indian state on its own Adivasi citizens. With this, I'll end today's webinar. Thank you so much for all of you for being with us.